Good evening, everyone. Everybody hear me out there? Okay, perfect. I was told not to move the podium, so I kind of have to stand to the side here. My name is Brandon Homer. I'm an attorney here in Jefferson, and I'm the president of the Greene County Bar Association. It's my pleasure to welcome you all to the special session of the Iowa Supreme Court this evening. These special sessions offer Iowans an opportunity to observe the Supreme Court proceedings in real time. Later tonight, after the court adjourns, everyone is invited to attend a public reception just in the hallway outside of the auditorium for juice and cookies. The justices will be at this reception, eager to visit with all of you, so please feel free to strike up conversation. A few need-to-knows, however. The judicial ethics prohibit the justices from discussing any matters that are pending before the court. That includes this case and anything else that they might be ruling on. The justices can, however, speak in general terms about the court procedures, the roles of the court, and other topics. This unique opportunity to meet with the justices is sponsored by the Greene County Bar Association and the Greene County Development Corporation. Before I explain the work and role of the Supreme Court and the process about what you're going to observe, I want to thank some people that have helped with the arrangements for this event. The Supreme Court thanks the Greene County Community School District Superintendent Brett Abbots and the Greene County High School Principal Karen Shannon for welcoming them and the rest of you to the school in this beautiful auditorium this evening. With additional thanks to Brett Gersma, Doug Hahn, Nick Lehman, Heath Talene, Andy Hess, Matt Middleton, Matt Fetcher, and Anthony Perry for the help with the planning, sound, live streaming, and stage setup. And thank you to the Greene County Bar Association for help in planning tonight's event and preparing the public reception. We also want to thank the Greene County Development Corporation for assistance with the event, and Greene County Sheriff's Office and Police Department of Jefferson for providing security for this evening. Now I'll discuss briefly how the Supreme Court works and the process that we are about to observe. Most of you have probably seen a trial, either in real life or on TV or in a movie or something like that. Maybe some of you have even served as jurors. What happens after a trial ends, when a party is unhappy with the result at trial, the party may appeal the case to a higher court, called the appellate court. An appeal is a higher court review of the lower court's decision or judgment to assure that substantial justice has been achieved. The right to appeal is a fundamental element of the procedural fairness in our legal system. The appeal process is very different from a trial. In a trial, one judge presides over the case and makes decisions. In an appellate court, a group of judges are collectively responsible for making the decision. Why do appellate courts have multiple judges making decisions? The basic concept of an appeal is the difficult legal questions are decided by a group of judges rather than merely substituting the opinion of one appellate judge over the trial judge. Tonight, you will see an oral argument. Oral argument is an opportunity for lawyers to emphasize their certain legal principles to the Supreme Court and for the Supreme Court to ask the lawyers questions about the case to clarify the parties' legal arguments. Don't be surprised if the justices interrupt the lawyer's argument to ask questions. Time is limited, and the justices may want to focus on specific legal arguments. Before the court begins, I want to mention a few items of decorum. During the proceedings, please be quiet and respectful of others. Please turn off all electronic devices, including cell phones. If you must leave the auditorium during the proceedings, please be quiet and respectful. You can find more information on the Iowa Supreme Court, the appeals process, and the summary of tonight's case in your program. Thank you, and please enjoy this unique opportunity to see the Iowa Supreme Court in session.
Court of the Thank you, everyone. Please be seated. Welcome to Court on the Road with the Iowa Supreme Court, and we will begin our oral argument at this time. The case presented to us tonight is Alex Butter and Sydney Stadola versus Midwest Property Management and others. Mr. Warnock, are you ready?
May it please the court. Christopher Warnock for appellants Alex Butter and Sydney Stadola. This is the root question in this case. Is a person's home their castle? In other words, do Iowa tenants have a right of exclusive possession? And do Iowa tenants and homeowners have an effective remedy for trespass in their homes? Both Magistrate Foster and Judge Kapros found that tenants do indeed have a right of exclusive possession, and that entry by a landlord without consent is a trespass.
Could I get you to come a little closer to the mic?
Certainly.
Thank you. That helps. Thank you.
That's under the Landlord-Tenant Act, a landlord can enter for certain specified purposes with legal notice, but only with the consent of the tenant. And that consent can be revoked or can be refused in the first place. This freedom with regard to exclusive possession and consent is absolutely key. You have to be free always to either say yes or say no. And we can see that from the statute, which gives the tenant the right of consent, but it's also inherent. We're talking about access to the tenant's home. If that exclusive possession is not exercised by the tenant, it's being exercised by the landlord. So in other words, if exclusive possession can be put into a lease, that's taking away from the tenant. The tenant always has to have the right to say no. And here's a perfect example. Tenant was perfectly happy to have repairs done. They agreed to it last week, but as they're showing up to do repairs, their child has just had a serious asthma attack and needs rest and recuperation. That right of exclusive possession means always being able to say, not now.
I thought the record reflected that your client testified when she wasn't given proper notice, she did in fact turn away the landlord from any showings.
That's correct. She had a misunderstanding of the law, though. What she thought was, as long as the landlord gives notice, they can come in no matter what. She did not realize that she had the right to say no. That is the most important thing that can come out of this case, is that the court makes explicit what is now only implicit, which is the tenants always have the
Wait a minute.
Why would we do that? Isn't there an obligation, an assumption that all people know the law? And if she said yes, I don't think the landlord has any obligation to probe her understanding of landlord-tenant law, does it?
Here's the problem. In order to get to the question in this case, which is the indirect consent question, which you're pointing to, we have to lay the foundation, and that foundation is missing. As I said, it's implicit, but it's not explicit. I look at the 562A19, the reason I brought this case, I look at that access statute and it confused me because it seems oblique about the consent. When can the landlord come in? When does the tenant keep them out? What we would propose is this, is that under the Landlord-Tenant Act and under precedent, the tenant has a right of exclusive possession and the landlord has a statutory license that's revocable at will by the tenant. This balances the need of the tenant to control access to their home, but allows the landlord to enter. Now, the tenant can always say no, but that power is not unlimited, because if you look at 562A35(1), if the tenant unreasonably refuses entry, the landlord can terminate the tenancy. They can't force their way in, but they can say, look, we need to repair, you haven't let us in to repair, we're going to notice you, you refuse again, and we can terminate the tenancy, and then they have a very effective remedy. They have a forcible entry and detainer remedy. They can immediately evict the tenant. This balances the need of the need of the tenant to protect access to their home, and the need of the landlord to have to enter for the specified purposes, for repair, for renovation, for inspection.
As a factual matter here, counsel, how many trespasses do you claim that there were?
Okay, first of all, the court found, the magistrate and the district court found there was 4 trespasses. Those trespasses were not appealed. So that issue of those, that's off the table, in other words. Those have not been appealed, cannot be reached in this case. However, what we appealed was the tenant, there was a massive number of entries, 48 showings over the entire tenancy. And the manager even admitted at trial that was a very high number of entries. The tenants complied, but they said, this is too much. So they complained to the landlord.
Mr. Warnick, what were the showings for? I'm kind of puzzled. I mean,
Oh.
this is very early in the tenancy. Normally, you're showing the apartment toward the end of the tenancy.
Let me explain a little bit about how Iowa City landlord tenants work. It's actually gotten out of control. What happens is, because Iowa City is on that academic calendar, all the leases turn over July 31st. Then what happens is, almost immediately after that, they start showing the place again. And so the poor tenants are in the situation of the landlord says, look, if you don't let us in to show, we'll rent it out to somebody else. So unfortunately, this is something that happens. This is an unusual case. 48 showings is really, I think, interfering with the tenant's use. It's too much. But like I said, the tenant complied. Now, ultimately, I think what they could have done had they known what the law was.
You brought it under point 19. Did you bring it as an excessive access case or as a trespass
No.
case?
Here's the problem with the statute. The statute, first of all, I believe is supplementary. It says, look, if you go ahead and you get an injunction, or if you leave, then you have this additional power. You can get this, special damages. They've left, the trespass is still open, because you need to be able to have some remedy if you stay.
Why didn't you ask for an injunction?
I actually thought thought about it. And here's the problem with the injunction. First of all, you can't get in a small claims court. You got to go to district court. You need to pay over $1,000 bond, and you need an attorney. And even with an
But isn't
attorney-
that, if you'd have gone that route, then it's statutory for attorney's fees, right?
Yes, that's correct.
So are you asking for us to consider that portion of a statute to give you attorney's fees
No,
on common law
not at all.
trespass?
Because we don't fit into the statute under those circumstances. We didn't get an injunction, and we didn't leave. I don't think the tenant should have to leave to protect the right of access to their home. I mean, that right of exclusive possession is absolutely essential to any tenancy. When you establish a tenancy, you have to give exclusive possession.
Yeah, but I'm a little confused. First of all, I want to get that number straightened out, too. Are you arguing that there are 11 or 12 additional trespasses? And the reason I ask is your briefing frequently says 12. But on page 21 of your brief, you said, and I quote, "The magistrate correctly found 4 trespasses which consisted of 4 entries without notice, one of which overlaps with the 12 entries outside the days and times agreed." So are we talking about 11?
Here's what I think about the facts in this case.
No, I want that question answered. Are we talking about 11 or 12?
I think that Appelli is correct, that in terms of entries outside the ones that were specified in the email, that there was 11.
Okay, so it's 11. Your brief keeps saying 12, but it's 11 if you take those 4 into consideration because there's overlap.
Right. Can I just make a point about facts, which is this? Neither the magistrate or the district court had the benefit of this court's ruling over what the standard is for implied consent. That has not been ruled on by this court. They're trying to do your job, and now we're trying to do their job by figuring out the facts. I'm confused by the facts in this case. I think this court should rule on what the standard is for implied consent, and then send that back to the bench.
Would you
of the
agree
district
with
court.
me that implied consent, it matters how the landlord interpreted the action, and it's not necessarily what the tenant may think?
I think it should be an objective. What I would say the
Well,
standard.
I'm not asking what you think. Would you agree with me that that's what our law is?
I don't think the court has ruled on it yet. This is the problem. This is an issue of first impression. What exactly is the correct standard for implied consent? Because here's what's happening. We have the Landlord-Tenant Act, we have the trespass precedent, and this court has never considered how those work together.
So, counsel, are you seeking a remand from us?
What I believe is happening in this case is that this court needs to establish what the standard is for implied consent in the circumstance of a landlord entering into a tenant's home, and then it needs to be sent back. Because if you look at what was done below, they're all over the place. There's different standards, different use, different facts.
Wait, so
The
what
problem-
standard should we use?
The standard that I believe that we should use is that, first of all, in order for the implied consent for landlord entry, they first have to follow the requisites of the statute. They have to follow 562A19. It can only be for specified purposes. They have to give that notice, and that notice has to follow the legal requirements of 562A8. Then the standard is, I think Appelli got it right almost, which is to say that if the words and conduct of the occupant are reasonably inferred by a reasonable person as being consent, it's consent in light of all surrounding circumstances.
I
So
want
are
to
you
get back to
saying-
that implied consent. You said there's no case law. This is first impression, but we have the restatement second of torts Section 892, and then we also have State versus Baller. And ultimately, that says that implied consent is about how the tenant's actions were perceived, not how they were intended. So isn't that an indication of how we have been going?
I think that, exactly, I think it's an indication of how we're going. It is that the issue that we're raising in this case is not, again, how does that work with the statute, though?
Well, I want to stop you for a minute here. So if we need to look at the actions, I find it interesting that on one side of the coin, you're saying no implied consent, and then on the other side, you're acknowledging that she did at times, he or she, at times give permission. So I'm having a hard time figuring out those 11.
I don't think that, here's what I would say about it. The tenant never gave permission. What the tenant did was, her belief was that she could not stop the landlord from coming in.
That's not true. She let him in before, several times, right?
Her testimony was that she never consented to that. Her belief was that she had to let them in.
That's personal and subjective, but can you see why her belief, if she didn't say anything out loud and just opened up the door and let him walk on in, how come that isn't an indication of what he believed to be consent?
What I would say about that, Your Honor, is that the key problem that this court...
Go back to what I just said. How can that not be perceived objectively if somebody opens up the door and doesn't say a word? Wouldn't you feel okay to walk on in?
I would agree with you 100% if that was the only facts in this case. But we have a situation, we have 48 entries where the tenant has previously complained about coming in, where the landlord has said, we'll only come in at certain times and comes outside those times, where the tenant repeatedly stops them from coming in, and then we have them showing up.
But doesn't the fact that the tenant stopped them on occasion, wouldn't that strengthen the inference that she gave actual consent on the times that she let them in?
Not when she's stopping them saying there's no notice. So here's what I would say about it. I think that our case on implied consent is the weakest part of our case.
Can you scooch up again? I want to make sure people can hear you.
I apologize. I think that the implied consent is the weakest part of our case. I think Appelli makes some interesting points. The problem is the facts are confusing. What I'm more interested in is establishing the underlying framework so this doesn't happen again.
Yeah, but that's not our job. Our job is to decide cases.
In order to decide the case, Your Honor, you have to build the structure.
I'm not sure about that. So there were the 4 situations, the 4 entries, and those were the ones that were, as I understand it, without the 24 hours notice, and those were deemed to be trespasses. The others were all with 24 hours notice, right? The other
yes.
actual entries. And so the 2 judges below said, well, those were consented and they complied with the statute that requires 24 hours notice, so there's not a problem with them. Is that finding supported by substantial evidence?
I think what I would say about that is that no, because I don't think they looked at the surrounding circumstances. I don't think they applied the correct standard because there wasn't a standard for them to apply. But I think that, again, we haven't talked about damages.
That's what I wanted to talk about too.
I think that's important as well.
I want to ask you a question on damages. What amount is high enough to meet your claim that that the trespass damages need to serve as a deterrence?
The legislature has given us a great guide.
But did you argue this down below? Or, to me, I think I saw something in the record where the number that was used for damages was, quote, pulled out of the air.
Your Honor, this is an issue of first impression.
Am I right about the record?
I didn't know how to set the damages because it's not economic damages.
Let's take it one step at a time. So at the trial level, the argument that was made, am I right that it was pulled out of the air?
I think that's a mischaracterization of it. I think that if I come in and say this is a pain and suffering, that also has to be pulled out of the air. And that's not something that's easy to set if it's a non-economic. But here's the thing. We've solved that because the legislature says 562A 35(1) for unreasonable entry, which is a statutory analog of trespass, the penalty is actual damages of not less than a month's rent and reasonable attorney fees. That tells us that the legislature takes an unlawful entry by a landlord very seriously. That gives us a model.
It sounds to me kind of like a mix and match. You don't, on the one hand, you don't want to pursue the statutory claim. You have to go to district court for that. You can't go to small claims court. On the other hand, in small claims court, you want the statutory remedy or some version.
Your Honor, I'm not asking for the statutory remedy. I'm saying, because the question is, how do we set the damages? You're pulling it out of the air. The legislature has spoken to us. The legislature says this is the
That's
type of
remedy
damages.
for that particular claim if you establish that claim, but that isn't the claim you
No.
you brought, nor is it the one you established.
Again, the question is, how do we establish the seriousness of this? Is this serious? Is this not serious? What's the level we put it at? The legislature has done that for us. They said, look, these unlawful entries, we take them very seriously. We would give a month's rent as actual damages.
Did you
So,
actually
Counsel-
request $250 in damages for each trespass?
My interest is trying to deter, because in order to protect
Let
the-
me ask you this again, counsel. Was it $250 per trespass?
I think my recollection is that that's what we asked for.
Thanks.
But
And
again,
I also want to look at the magistrate's order, which I think was repeated by the district court order on appeal. The plaintiffs request $250 in damages for each trespass, but acknowledge that number was essentially pulled out of thin air.
again, I think that's a mischaracterization of,
Did you appeal that?
yes, we appealed the damages. You bet. I mean, I guess what I would say about this is that when you're talking about an issue of first impression, when the court has never spoken on it, and it's a non-economic damage, it's difficult to set what the damages are. I didn't know what they should be because no one's ever done it before. By the time we got to the court and we briefed it, and that's what's so useful at this process, to go to the small claims, to go to district court, and now to brief it, to think about it carefully, to me, it seems the logical thing is to look at the guidance from the legislature on an analogous action, analogous
Before,
damage.
you're out of time, but before you step away, I'd like you to address attorney's fees on your first go-around. And one, what are the importance of that as a deterrent? And two, what's your path to it when the lower courts found you only won under a common law trespass theory where you can't get fees?
Yeah. What I would say about attorney fees is that attorney fees are not very often given in small claims cases. Normally they're pro se. And even in situations where attorney fees are granted, I think it's appropriate to leave it to, as you said, it's almost as egregious. It's one step below punitive damages, not to be granted as of course. In this case, the argument is that, well, trespass is a tort.
That's a pretty good argument, don't
That's
you
a pretty
think?
good argument in the general terms. But if you look at the specific circumstance of a landlord's entry, in order to have a tenancy, the landlord has to grant to the tenant exclusive possession. Trespass is a violation of exclusive possession. The landlord has to promise to the tenant, I will not trespass, in other words. So there's always an implied covenant of exclusive possession in every tenancy, and that's whether it's oral or written lease. So when the landlord trespasses, they always violate that implied covenant of exclusive possession. Having violated the implied covenant of exclusive possession, they violate the rental agreement, and then attorney fees under 562A12.8 are appropriate. So
Mr.
that's
Warnock, you'll get to
syllogistic.
come back in a little bit. Your time is up. You'll
Thank
come
you, Your
back in a
Honor.
little bit.
And
Okay.
I hope you can give some more time for reply.
You'll get a
Thank
few more
you.
minutes, 5 more minutes when Mr. Ford is done. Mr. Ford.
May it please the court, counsel. Thank you, Greene County, for hosting us this evening. What I want to start out with is pointing out that the appellants in this case are asking you to establish a new standard for a implied consent in a trespass case. And it's very clear in their brief that they want a statutory term to be included in a common law standard. In other words, they want to say, before you look at anything at all, you have to see if the landlord complied with Section 19 of the Landlord-Tenant Act, which says that you have to give 24-hour notice. My position is that the thing that you look at in a common law trespass case is whether the alleged trespasser has privilege to enter, and that privilege is usually established by consent. So, certainly, in my opinion, consent is the key, and consent can be given even in the complete absence of a notice. So let me give you an example. So let's say, for example, the tenant calls the landlord and says, my faucet is broken, can you please come fix it? The landlord responds and says, I'll need to stop by sometime, take a look at it and see what I need. So he goes to the house without giving a 24-hour notice. He finds nobody at home, but also outside the door, he finds a brand new faucet. He finds a toolbox, a key to the front door, and a note that says thank you. Okay, in that situation, the landlord did not give a 24-hour notice, but I think it would be reasonable for a court to say that landlord had implied consent to enter because the tenant left all those goods there at the door for him to come in.
Could you respond to Mr. Warnock's argument at the end of his discussion that common law trespass in this statute are sort of interwoven? You can't have one without the other, and
Yeah,
therefore he's entitled to fees.
I think you can certainly have one and not the other. There's a lot of different cases where this court said you can't recover in for instance, a case based upon the seller disclosure statement requirements when you didn't bring that action. So I think that applies in this case. I think it's important for you to realize that they didn't sue for they didn't sue for a statutory claim at all.
Well, so, counsel, here it's interesting, though, because the district court granted only $147 in damages. That number seems strikingly low. If
Okay.
we weren't to go with that number, which is the daily rate, and with one of the days a half-day rate, right? What numbers should we go with?
Well, so what I would say to that is, the appellants in this case cited a couple cases where they say that, mathematical certainty is not required. And I'm not saying that's the case either. But those exact same cases also say that the plaintiff has to give the court something on which they can estimate what the damages are. And in this case, they did nothing whatsoever to try to prove what their damages are.
I have a question about your brief asks us to affirm the district court, but then you also claim the district court should not have found 4 trespasses. How did you preserve that? If you did not file a cross appeal?
Yeah, that was not in my intent, and I'm sorry if that's the way
So
you
are
interpreted
you
it.
agreeing that there's 4 out there we need to talk about?
I'm not disputing that there were 4 trespasses
Okay.
at all. No.
So do you think whether we find 4 or 11, I think is the number I was talking about earlier, does it matter if it's 4 or 11 when we're trying to determine the amount of damages? Or would that same formula that was used by the magistrate in the district court be the same if it's 4 or 11?
I think it should be the same. Because, for an instance, where there was an entrance but was not a trespass, I don't think there can be damages awarded for that.
Didn't they sue at the outset of this case for both common trespass but also statutory violations? Quote from their petition, KMB repeatedly entered premises causing multiple trespasses and in violation of 562A19 and 562A35-2, and then they seek their attorney's fees under several statutory provisions. Weren't they suing under both common law and the Landlord-Tenant Act?
Well, let me say this about that. So that might be what their petition said, but they were very, very and repeatedly clear, both in their pre-trial hearing memorandum and in the arguments they made directly to the court. This is a common law case, not a statutory case.
So they gave that up along the way?
They waived it, yes.
Well, it's back in their brief on appeal, or at least for fees under subsection 12.8.
Yeah, I don't dispute that, but their whole approach to this entire case from the very beginning was based upon common law trespass, not a statutory claim, and I can tell you why. If you look at their hearing memorandum and their damage calculation, they wanted the court to consider this case to be a tort because they wanted both of the defendants to be held jointly liable. So they made arguments in their documents about why, if this is a tort case, we can hold both defendants jointly liable, not if it's a contract case. So that's why they wanted specifically and over again, told the court this is a common law trespass tort case.
If you assume this is they did sue under the statute, can you get attorney's fees under the heading of deposit without a claim for a deposit refund?
Yeah, I think that's a very interesting question. And the attorney fee question is, I think, the most interesting aspect of this case. And we briefed this extensively. And my opinion is that, according to the appellants in this case, okay, any successful party in an action on a rental agreement can get fees, regardless of whether it's based upon a rental deposit dispute or not. That's the appellant's position. My position is that that doesn't make any sense when you look at the entirety of the statute and you compare other specific sections of the statute that say, for instance, if you have a breach of contract action, then you have to prove willfulness before you can receive attorney fees.
So counsel, when it just says effectively any action on the contract gives rise to a fees claim. Are we sort of to infer that the legislature made a mistake by not specifying that it's limited to a damage deposit situation?
Well, I think the legislature certainly could have been more clear about that. But the point is, I think you need to look at the entire statute. And, you know, if you take the language alone of Section 12, okay, that is a general statute, and it completely throws away the specific statute that addresses a noncompliance of lease matter. So if you have a case, for instance, in this particular case, if the plaintiffs had brought a case for a breach of contract, then they would certainly be under Section 21 of the code, and that would require that they prove willfulness in order to receive fees. Okay, maybe that's why they didn't do it this way, because they wanted to be able to say, I'm pointing at Section 12, not Section 21, so I should get fees just because I win.
So, Mr. Ford, I mean, you have sort of two levels to your argument, as I understand it. One, you're saying that this 562A12.8 only applies to security deposits. The other is, even if it has a broader application, this isn't a, quote, action on a rental agreement?
Yes, that's correct, yeah. And I don't think those two arguments actually are exclusive of each other. I think under 562A12, paragraph 8, it's got to be an action on a rental agreement. In other words, a breach of contract. But it also has to be a breach of contract that's based upon a security deposit dispute.
Let me go back to the question that I asked Mr. Warnock. What is it with all these showings so early in the tenancy?
Yeah, so that's not on the record, but I can tell you what happened is that this was not a tenancy that started at the beginning of the academic year.
I noticed it was like a 10-month tenancy.
I can't recall. That sounds right, but it didn't start at the beginning of the academic year. So this is a particular property that tenants like. There was a lot of interest in it, so they need to show it. I don't know.
Why
Well, I mean,
48
they
times?
can't-
Why didn't you run it like to number 2?
Right.
I'm sorry.
So
I'm sorry, I didn't
why
hear you.
did it take 48 showings? If it was that popular, why didn't someone?
I think there are a lot of interesting properties in Iowa City. There are a lot of options for tenants
I
to
want
choose
to ask you
from.
about the damages. The $250 might have been pulled out of the air, but Ms. Nadala worked from home, and so this really interfered with her office work and having to rearrange meetings. Why isn't $250 kind of like a pain and suffering kind of a number?
Well, maybe it is, but that certainly was not developed at the trial whatsoever.
But those facts are in the case, isn't it? She had to change meetings, she had to rearrange her schedule, she had to hang up on meetings. That was in the record, right?
Well, it's not really in the record if she had to do that for the 4 instances that were actually held to be trespasses. So she had to do that for some of the entrances that were not trespasses.
Going back to the attorney's fees briefly, so what troubles me about this language about, sort of any action under the contract or thereabouts, it's in the damage deposit section of the statute. Are there damage deposit actions out there that are not under the contract, or?
Well, here's my thoughts on that particular issue, is that the landlord-tenant statute does not establish for the landlord a right to receive a security deposit, and it does not impose on a tenant the obligation to pay a security deposit. So, in my opinion, anytime you have a dispute that involves a rental deposit, it is inherently based upon the lease agreement, because the lease agreement is where the obligation to pay the rental deposit comes from.
Counsel, why shouldn't we view the email that limited the dates and times for these showings to be an amendment of the rental agreement?
Yeah, it certainly was never intended to be an amendment. They didn't talk about it in those terms. It wasn't a separate agreement that was enforceable either. There was a point later in the tenancy when Sydney said, you gave us this email before, we're still having these showings, I'd like to come to an agreement about that, which shows that it was an agreement at the first time.
Does it reflect on her consent, though? When she complained about it and they said, okay, you're right, we won't do it this many times, we'll do it during these timeframes. And then they didn't do it within those timeframes. Doesn't that reflect on her consent?
I do think it's part of the overall analysis, but I think you need to look globally about what all of surrounding circumstances are, not just the ones that they want to focus on. So,
Well, but you want to just focus on the fact that she opened the door.
I'm sorry?
You just want to focus on the fact that she opened the door, and that does away with everything else.
Well, there's nothing in the record to say why the landlord continued to ask for showings after they sent that email. Okay, there's nothing in the record to say that.
But
It's
does that matter if they agreed to a certain time and then they went outside of that time? Does it matter why?
Well, the point is, even though they sent that email, they continued to send notices after that, and sometimes those notices were for showings outside of the schedule in that email, and every time they did that, when they came to the door, Sydney would let them in. Okay, that's, in my opinion, pretty darn close to express consent.
But then she came back and said, hey, you're not abiding by the emails, I want to come to an agreement, right? Doesn't that reflect that she wasn't consenting, but she was under this misperception that she didn't have a choice?
Maybe, but that could still be just the negotiation between the parties. And again, after that happened, they continued to give notice, and she continued to willingly let them in.
Can you help me understand the difference, the other 11? Why are you arguing today there are not 11 additional violations?
Yeah, so as I understand it, what the appellants are arguing is that after the email went out and the notices went out for times of showings that were outside of the schedule that was contemplated in that email, they think every one of those showings is a trespass, even though she gave implied consent when they came to the door. So I think it's important to keep in mind in this case what the appellant's approach to the case was from the very beginning and all along, okay? They approached this as a common law trespass case, not a breach of contract case, not a statutory case. And they were explicit and clear in their reasoning for making those requests. And so that has a lot to do with why, in my opinion, the attorney fees should not be awarded in the case, okay? They say simply because their lease agreement has an implied covenant of possession, that's enough to make the trespass common law action an action on a rental agreement. I argued that that's just a tenuous relationship because you can have trespass, and often do have trespass, even when there is no agreement whatsoever. So, for instance, you can have a tenant who's a tenant at will, who has no contract. They're still entitled to be free from trespass, okay? But that doesn't mean they should get attorney fees. It's not an action on a rental agreement because there's no rental agreement. I wanted to mention one thing that the appellants raised with regard to the Uniform Act, and that's with regard to attorney's fees. They said in their brief that the Uniform Act does not include the specific language in Iowa's statute, Section 12. And while I agree that that particular language is not in the Uniform Act, it's a little bit misleading because the Uniform Act does include a specific provision that addresses attorney fees, and it addresses attorney fees only in the case of a rental deposit dispute. Okay, so for instance, the Uniform Act is section 2.101C, and it says if a landlord fails to comply with the obligations with regard to the security deposit, then the tenant can recover money due to him under the lease with damages in amount of 2 times the amount wrongfully held plus attorney's fees. That's what the uniform statute says. Iowa statute broke that apart. We have 2 different subsections in section 12. Paragraph 7 contemplates punitive damages against the landlord, but only if they are shown with bad faith retention. And section 8, paragraph 8, contemplates fees to the prevailing party, but not just to the tenant. So under the Uniform Act, only the tenant could get fees, not the landlord. So the way the Iowa legislature broke it apart, I think is more a way to show that we want to say fees are appropriate, but only if there's bad faith.
May I, Chief?
Go ahead.
Yeah, but Mr. Ford, I mean, you say they were just breaking it apart. Isn't it a reasonable inference that by not adopting that wording, they were not limiting fees to the security deposit situation. And that's what the language literally says, in any action on a rental agreement.
I think the more reasonable interpretation is that the legislature wanted to say landlords are entitled to receive fees as well, not just the tenant. But at the same time, if you're going to get fees, you got to prove bad faith. So that's why the Iowa legislature, in my opinion, didn't adopt the exact language in the Uniform Act. And I point out that the revised act, which Iowa has not adopted yet, includes one section that addresses attorney fees. It's not broken apart into different types of claims. There's one section in the revised act that says you can get fees, but it also requires willfulness or a lack of good faith.
Is the existing Iowa statute on fees ambiguous?
Which statute?
12 sub 8.
I think on its face, by itself, it is ambiguous. So I think that's why you need to look at the entire statute, the scheme of the entire statute. When is it appropriate for fees to be awarded in a certain type of case, and what you have to prove in order to get fees in that type of case.
Thank you.
Thank you.
Mr. Warnock. You'll have 5 minutes for rebuttal.
Thank you, Your Honor. I think the attorney fee question is very simple. Plain language. All you have to do is look at the plain language of that. It's totally obvious. Any action on the rental agreement. And we don't need to look at the headings to understand that. We don't need to look at the structure. All we have to do is look at the plain language.
Well,
that's
is this
that's
an
all we need.
action on a rental agreement? Is it a common law trespass claim?
Exactly. His example about the tenancy at will. Tenancy at will is a tenancy. All tenancies include an implied covenant of exclusive possession. You cannot be a tenant without exclusive possession. You have to get that exclusive possession from the landlord. That's inherent in every single tenancy. Never happens without it. Implied covenant, if you violate an implied covenant, it's exactly the same as implying the rental agreement. It's
So
it's
is this a
syllogistic.
breach of contract claim or a tort claim?
It is in a liminal state of existing in between those. If you think about an implied covenant,
There's no such thing.
okay, implied covenant is an implied
You can
covenant.
pick a path, but we're not
Here's
gonna
the
go
problem.
there.
No, just listen, hear me out. Implied covenant is not a result of the explicit contract between the parties, but arises as a matter of law when a contract is formed. And that's the same thing as exclusive
If
possession.
it's quasi-contractual, why wouldn't the damages be measured by contract, which would be exactly what the district court did here?
Look at Mies v. Fox, with the implied warranty of habitability. In that case, the court said, once the implied habitability, once that implied covenant has been violated, that the normal contractual remedies come into play. So that's exactly what's happening in this case.
Mr. Warnock, what I'm hearing you say is that every landlord-tenant lawsuit between the two of them is an action on the rental
No,
agreement.
I'm not saying that at all. I'm saying any landlord violation of exclusive possession is. Not every landlord case. Because here's the problem with what the appellee quite rightly points out, that the plain language of the statute says on a rental agreement. What that means is, the way that the courts have been applying this in the past is that any violation of the Landlord-Tenant Act gives rise to attorney fees under 562A 12.8. That doesn't follow the plain language. However, violating the rental agreement is violating violating exclusive possession is violating the rental agreement.
Over the course of this lawsuit, did you narrow your case to just common law trespassing?
Let me explain something about this. This starts out as a small claims case.
Okay.
And we expected to appeal this. I was hoping to be right here 3 years ago. So I filed a 14-page memorandum laying all our cards on the table. Now, my opponent, very clever, reserved his opening, filed nothing, and only made his legal arguments as soon as the facts had come in. Had I known what those arguments were, we could have adopted it because it's small claims. We can change our everything at small claims level, but I had no idea what their response was to our arguments. So the first time we ever got any detailed legal briefing was on the district court level. So to come in to me and say, oh, you didn't do this case at the small claims level is ignoring the reality of small claims, which is
That's
an
what
informal
179B
proceeding.
is. I know they're not called that anymore, but did you do any kind of a motion afterwards to say, I would like you to expand on the ruling or ask for additional time if you felt like?
No, I didn't. And because you can't, in small claims, again, once the judgment is done, you're over. There's no 904.
No, but you just told us that you didn't know till the evidence was started to roll out what was going on. I've been in magistrate court for many, many years. I could certainly have said, excuse me, Your Honor, could I have more time? Could I continue today's hearing to compensate for what I just learned today? Couldn't that have been done?
Your Honor, that would have been a very wise thing for me to do had I thought of that. I did my best in terms of filing the memorandum. I set that up. And, you know, as I look about it now, I think that would have been a great idea to do that. However, like I said, this case did go through the district court. It was extensively briefed at the district court level. All the arguments that I'm making now are the same arguments I made at the district court. So,
But the district court level is acting as an appellate court when it's a magistrate case, so everything had to happen and come in at the magistrate level, right? I know legal
I
arguments
guess
are
what
legal
I would
arguments.
say about that, Your Honor, is that
Well, aren't I right that legal
no, I don't
arguments...
think. I think that's incorrect because
Well, let me finish.
we
Hey,
raised.
let me finish.
Yeah.
Aren't legal arguments not evidence? And that's what you're talking about in all your briefing at the district court level. I'm talking about the evidence that was
No,
introduced.
I'm not trying to introduce any new evidence. I'm not doing it. We did ask for attorney fees. The specific arguments that we make, though, I can't make the Supreme Court brief at the small claims level. We need to go through the process in order to be sure about legal arguments. So we did ask for attorney fees, and my view is this, is that anytime the landlord trespasses, it's both contractual and a trespass. So if you say that they trespassed, that you're making a claim for both a contract and a trespass violation because it's inherent in that trespass. If you trespass, you are trespassing against that general right of exclusive possession with that specific covenant that's also made.
May I, Chief?
Yes.
But if you're pursuing an action on an agreement, then don't you have to establish a violation of the agreement? And the agreement has an access provision in it, right? You weren't claiming that access provision was violated, were you?
You know, I considered making that. It's an argument that I made, and I think on district court, and then dropped it because the appellant raised that. He said, "Look, you didn't raise that below." I said, "You know what? That is a good point. I'm not going to pursue the argument." I could have, had I again been prescient, I would have said, "Look, in the agreement there actually is an access provision. They quote the 562A19 in the contract. Had I known that this was going to be an issue, I could have done that. But I said, no, that's not the right thing to do. I'm going to stick with the arguments that I made at the small claims court level." So we did drop that argument. So that would have been an excellent argument had I thought it in advance. But as I said, I didn't think it was right to do that.
Thank you.
Thank you, Your Honors.
The case of Butter and Stadola versus Midwest Property Management and others is hereby submitted. Now is a different time. Normally, if we were in Des Moines, the bailiff would gavel us out and we would all stand together and we walk out our side door. We would take off our robes, get a cup of coffee, and then we'd meet up in the